Hello, this is Professor James Strickler, and this is a course in American government. This lesson is from Unit 8 about civil liberties. It's Lesson 10 about due process of law. In this lesson, you'll learn about the two due process clauses found in the United States Constitution. You'll learn about the exclusionary rule, about the Miranda warning, and about the right to counsel. In the previous couple of lessons, we've been talking about how the United States Supreme Court can use its power of interpretation to effectively create, define, or even destroy people's rights. In this lesson, we'll be discussing how they can use that power to manipulate also the way our rights are protected, in the way that they interpret the concept of due process of law. The first thing, though, that we need to remember is something that has been mentioned in this course in passing along the way. And that is that there are actually two due process clauses found in the United States Constitution. The first one is in the Fifth Amendment. You may have noticed previously in this course when we talked about the Fifth Amendment and what's found in it, that this due process clause was there. It says that no person can be deprived of life, liberty, or process without due process of, life, liberty, or property without due process of law. We've previously talked about that what that means is that the government can't execute you or imprison you or fine you without going through certain correct procedures in order to accomplish that. Now, this due process clause is found in the Fifth Amendment, and there's a particular importance of that. Because the Fifth Amendment is part of the Bill of Rights, which you've previously been taught, means that it only applies to the national government. This due process clause is then a restriction on the behavior of the national government. It's saying that the national government can't deprive you of life, liberty, or property without going through correct processes to do so. You've also seen in the course this separate due process clause, which is found in the 14th Amendment to the Constitution. The 14th Amendment was one of the Civil War amendments, added after the Civil War to restrict the power of the states. That amendment says that no state will be able to take away your life, liberty, or property without due process of law. So just as the Fifth Amendment due process clause restricts the behavior of the national government, the 14th Amendment's due process clause restricts the behavior of the state governments, telling the states that they can't execute you or imprison you or take away your property without going through certain correct procedures. But having said that the national government and the state governments can't do those things to you without going through correct procedures, doesn't really tell us all that's going on. Because just because you are entitled to due process, that does not tell us how much or what kind of process is actually due to you and in what situation. In other words, there's something that needs to be defined here. What exactly does due process mean? And so the court has been able to interpret this clause, particularly in this lesson, to interpret what sort of procedures are required to take away somebody's life, liberty, or property. And I'm going to give you three examples from United States Supreme Court cases where the Supreme Court dramatically changed the meaning of a particular element of due process. The first of those cases is from 1961, a case of Mapp versus Ohio. This involved a woman who was arrested when the police barged into her house looking for a suspect in a bombing who they thought had taken refuge in her house. As they then went through the house searching for this bombing suspect, they opened up a chest in her basement and ended up finding what was at the time considered to be obscenely pornographic material there. She was arrested, according to the laws of the time, for having this, and prosecuted. The case went all the way to the United States Supreme Court. And the argument she made was they shouldn't have been searching in her house or in that chest without a search warrant. Well, the cops admitted they did not have a search warrant, but they said it doesn't really matter. We found this material that was illegal, and she should still be punished for it. But in deciding this case, the United States Supreme Court said that if evidence obtained in some sort of illegal manner, such as an unconstitutional search without a search warrant, may not be presented in court. In other words, it must be excluded from court. This is a concept that in modern America seems kind of obvious to us. It's something that we've probably seen in many television shows, movies, things like that. We've gotten used to the idea that if something is obtained by the government without a search warrant, they can't use it in court. But prior to this decision in 1961, they could. And the logic prior to this decision was that even if the cops acted inappropriately, we still have evidence of the actual crime. Why should we have to throw that out and let the criminal go free? Let's take an extreme example. Let's imagine the cops went into someone's house without a search warrant, and they found several half-eaten dead bodies in a freezer. And they said, oh my gosh, the person who lives here is a serial killer cannibal. Well, should they have to pretend they didn't ever see those bodies? Should they not be allowed to bring that evidence into court just because they didn't have a search warrant, and therefore let the serial killer cannibal go free? Well, prior to 1961, the answer would be no. They don't have to ignore that evidence. They can bring it in court. They can throw the guy in jail, into prison. Now, there were ways for the person to sort of fight back against the evidence having been illegally obtained. For example, they could potentially sue the police officers for violating their constitutional rights. And in that way, there was at least some incentive for the police not to engage in these things, because they could personally be liable in court for what they did. But the criminal would still go to prison, was the idea. The important thing was that a guilty person wouldn't walk free just because of a loophole in the law, so to speak. But after 1961, when the United States Supreme Court laid down this rule in Mapp versus Ohio, now if the evidence is obtained illegally, the government must walk away from it. They cannot present it in court. Now, that doesn't mean necessarily that the guilty person will always just go free. The government would have to find some other way to get to wherever that evidence would have led them. But in many cases, if they're not able to use the evidence that they found, there isn't going to be no prosecution. And so through this exclusionary rule, we end up having many people who are likely to be guilty not being prosecuted if the government makes a mistake and searches them inappropriately. The next Supreme Court decision that shows how the Supreme Court can essentially rewrite what due process means is the case of Gideon versus Wainwright. Now, in the United States Bill of Rights, one of the provisions it has there for the national government is that a person is entitled, or I should say not entitled, has a right to counsel. Now, what is meant by that, as it was originally understood, was that a person can go get a lawyer to help them in court if they want to. They don't have to, but if they want to, they can go get one, and the government may not stop them. And that's what that right to counsel was always considered to mean. The United States Supreme Court had incorporated that right to counsel found in the Bill of Rights as applicable against the states via the doctrine of selective incorporation that we've discussed before. So the state of Florida, where this case came out of, was also bound by that right to counsel provision in the Bill of Rights, that if somebody wanted a lawyer, they had to allow them to have a lawyer. But what about the case of someone like Gideon, the person who appealed this case to the United States Supreme Court? He was a man who was arrested for petty theft. He came into court. He said that he would like to have a lawyer, but he couldn't afford one. And the government said, well, if you want one, you can go get one, but that's it. And so he didn't have a lawyer. He ended up being prosecuted, found guilty, and went to prison. Well, while in prison, he did legal research and ended up handwriting an appeal to the United States Supreme Court that you see a picture of on this page. His a petition for a writ of certiorari was accepted. The United States Supreme Court took his case. They assigned a lawyer to argue the case for him, and he ended up winning. And basically the argument that he made, that the Supreme Court accepted, that then became the law of the land because of their interpretation, was if a person can't afford a lawyer, the government must pay for one for them. The United States Supreme Court declared that to be an element of due process, that in order to fairly take away somebody's life, liberty, or property, you have to make sure that they have a lawyer to help them, and if they can't afford one, the government has to get one for them. Now, whether that's right or wrong isn't the point. The point is that that idea that the government had to pay for your lawyer for you wasn't a mandatory provision of the Constitution before 1963. But notice that there wasn't some amendment in 1963 that changed the Constitution. Instead, the United States Supreme Court made it a mandatory thing for the government to do, to provide a lawyer for people, as of 1963. The Supreme Court effectively changed the Constitution with this decision. The next example is from a case in 1966, the famous case of Miranda versus Arizona. I say it's famous because probably everyone listening to this lesson can recite the Miranda warning from heart, even if they don't realize they can. They've seen it recited in so many television shows, so many movies, they can probably do so. The Miranda warning is where a suspect is told they have the right to remain silent. Anything they say can and will be used against them in a court of law. They have a right to an attorney. If they can't afford an attorney, one will be appointed for them, etc. We've all heard it a million times. Well, where that came from was in 1966, we had a man appeal a case to the United States Supreme Court who had been arrested for the crime of rape. While being questioned by the police, he had confessed to actually engaging in the rape. Later on, when his lawyer found out that he had confessed, the lawyer came up with an argument that this man would not have confessed if he had known that he had a constitutional right not to be a witness against himself, the right to remain silent that we've talked about previously in this course. His lawyer said Miranda didn't know that he could remain silent, and that's why he didn't. And therefore it was an obligation of the government to tell him he could remain silent, and they had failed to do that. Well, Miranda won the case, and the United States Supreme Court declared in 1966 that from that point forward, that suspects would have to be warned of their right to remain silent, or anything they say couldn't be used against them, because it would be assumed that they didn't know that they have to remain silent. Again, like the two previous cases, this is an example of the Supreme Court in effect changing the meaning of the Constitution. Prior to this, yes, you had a right to remain silent, but it was up to you to decide. It was up to you to be aware. While after this, the government must now warn you, tell you, educate you about it on the spot before they can question you. The Constitution was not amended to create this change. Instead, the Supreme Court just made this change. So, from these three cases, you can see that the United States Supreme Court can, in effect, create procedural rights for people as it sees fit. And once they have the power to create procedural rights, that means potentially they can also destroy procedural rights if they want. Now, let's review what we learned in this lesson. Why are there two due process clauses in the Constitution? Is it that the first was somehow voided? Was it that the first one was for the colonies and the second one for the Union? Was it that the second amended the first, in other words, changed it? Or is there that there's one due process clause for the nation and one due process clause for the states? The correct answer is there's one due process clause for the whole for the United States government, the nation, and there's one for the states. What is the exclusionary rule? Is it that illegally obtained evidence is barred from court? Is it that pardons can't be appealed? Is it that some defendants are given priority over others? Or is it that excessive fines are prohibited? The exclusionary rule says that illegal evidence must be barred, can't be presented in court. What is the Miranda warning? Is it that defendants must tell the truth? Is it that religion can be infringed upon? Is it that suspects must be told their rights? Or is it that free speech is limited? The Miranda warning is that suspects must be told their rights. What did GIDEON versus WAINWRIGHT change? Did it change that defendants are now allowed lawyers? Did it change that suspects now may stay silent? Did it change that states must now provide lawyers for defendants? Or did it change that suspects may now confront witnesses? GIDEON versus WAINWRIGHT decided that states must now provide lawyers for people who can't afford them. That completes this lesson. The next lesson will also be from Unit 8. It'll be Lesson 11, about substantive due process.